with the existing structure. In other words, if they treat corporations as de facto governments, things become confused. And the same situation, of course, exists when you get into dealings with multinational corporations who are very easy to observe as having some governmental powers. Arlen Tussing, I think it was this morning, mentioned that a good many of the multinationals are beginning to assume the aspect of public utilities. Yet we must always remember they are not regulated like utilities yet, although Senator Jackson may have plans in that regard. But the difference between now and what went on in the West, of course, is that there's a large body of state and federal laws and regulations affecting land management which did not exist when the above institutions reigned as de facto governments. The reason they were able to reign as de facto governments is because they controlled land or water. In the case of the private lands, the questions which must be answered by the people concerned is whether they wish to have the ability to ameliorate, when possible, the effects of federal and state laws through local ordinances. It's important to remember there will continue to be several areas where local jurisdiction will not apply, but equally important to realize that laws can be passed which do not directly apply to any area of jurisdiction, but which do have effect upon it. Probably the most damaging situation that we run into in the United States today is where subordinate governments, and the very fact that we view them as subordinate governments, I think, is one of our problems, but subordinate governments such as local governments are not able to exercise planning controls over the federal and state governments in such simple matters as zoning, however imperfect a tool it may be, or in such matters as health ordinances and so forth. I think that, in our attempt to achieve overall equity in the United States, we may have gone overboard in some areas. And if we're going to have responsive government, why, somewhere along the line there must be a tie at the local level between the federal and state agencies. Now, moving to the area of local land ownership, I'm not really going to talk all day, Esther. I've just got a lot to say. Now, in some boroughs of Alaska, a considerable amount of land will fall into this category. And as some of the larger boroughs are formed, why, we're going to have enormous amounts of land. And the great bulk of these lands will probably remain public lands. I just had a brief conversation with John Reeder about the North Slope Borough, and the North Slope Borough is not a good analogy in this case because most of the land has been preempted up there. However, if there is any state-selected land which is available, why, the North Slope Borough can select it, and I would imagine North Slope is going to be taking steps to begin its land selections, which should be 10% of state lands. Surface only, yeah. But these are going to be, the ownership of local lands is going to be a major factor in Alaska. And those local lands will be largely controlled by local governments. In those areas of Alaska most affected by the claim settlements, there will probably be a checkerboard of private and local government-owned land in the immediate vicinity of the towns, assuming that most boroughs will select lands adjacent to urbanized areas. Since there will be a good deal of private land for sale after the provisions of the Claims Act prohibiting transfer have run out, it is unlikely that the local government land can be transferred into private hands except at the expense of the native corporations. But it is likely that if the boroughs are formed and secure title to their land before the right to transfer title is available to native landowners, then the bulk of land sales in a region will be of the governmental lands, and there would be a good deal of pressure on local governments to sell those lands. However, in the areas spoken of above, political control at the local level will ordinarily rest with the native and the native landowners, and policies can be made that will cause the local government lands to not be competitive in land markets with private lands. The same option will not, of course, be available for federal and state lands, which are legally available for transfer to private title. In this case, the local residents, of course, will have to secure redress from the state legislature and the Congress in a somewhat chancier operation in the long run, despite the successes of recent years. Now, political control of the disposition of state lands and their regulation has in the past been largely the purview of the state administration. Only in the creation of parks and other special land designations can the legislature normally act. There is no effective mechanism requiring coordination of state land distribution policies with local governments. And indeed, the state legally challenges the rights of boroughs and cities to exercise such management tools as zoning. However, in practice, local jurisdictions have zoned state land and has not been challenged as yet. Here again, if the views of the state on land distribution and use are in conflict with those of the local population, there is no legal redress except the courts. Naturally, political pressures may be brought on state agencies, on the governor, and ultimately on the legislature, if time exists for that body to have effect. In many cases, the pressures on the other side may exceed the local pressure. Needed, of course, are statutes which give local jurisdictions some control over state land utilization. The same general argument will apply to those federal lands which are not specially designated. In cases such as military withdrawals, where federal land uses will change, certainly some measure of local control should obtain. Otherwise, the whole concept of planning is defeated. I think that sometimes we look for very complex solutions where possibly we should be looking for simple ones. If we move ahead and form effective local governments in Alaska, I would see no barriers to whereby the federal and state agencies involved should not be able to institute mechanisms which will truly coordinate with those local governments and utilize the local government as the point of coordination. Certainly with the A95 process and others, we've begun to creep into this area. And it's just a matter of expanding some of the things which hopefully will be the good side of revenue sharing and other such concepts. The fear of the federal agencies is simply the fear, in many cases, not of their land control, but of an overweening bureaucracy, which is not going to be responsive to the needs of the residents of this state. The same fear exists in many parts of the states of the state agencies. And in many parts of the state, why, of course, boroughs. Each superior form of government is perceived by the citizen as an overweening impact upon his area, which limits his rights. And I think that as we move into these cooperative systems, the fears of the local resident that his rights are going to be co-opted to serve larger goods can be ameliorated in most cases. But it's going to have to be a kind of discussion framework where these things are brought out at the local level. And here, once again, we've begun this process with land commission hearings, with many agency hearings and so forth. We haven't done enough of it, largely a matter of finance and time. But carrying forward with this kind of framework is the only way that we're going to be able to achieve successful solutions for every part of this state. Every time we try to do it broad brush, we're going to paint somebody's options out where possibly it's not necessary to do so. I think I've talked enough, Esther.
No, I don't think you've talked enough, Walt, but I think Walt's given us a good perspective on the multidimensional nature of land use problems, and the fact that a public land approach to it necessarily has to involve many different considerations, and certainly it's not possible for 4 people in 2 hours to cover all of the opportunities for legal change or for the law to achieve our purposes. Point, which I think those of us who work closely with the implementation of the Alaska Native Claims Settlement Act often forget to say again, and that is the point that the corporate ownership of native lands is not the same as local government in those areas, and that there is a very big gap in Alaska with respect to the provision of governmental services through local governments that are responsive to all of the people in rural Alaska. And it may be that you will have exactly the same people serving on a board of directors for a corporation that owns a good part of the land in an area, and also serving as borough assemblyman or city councilman on a governmental body, providing the delivery of governmental services in that same area. And it is something that needs to be said over and over again, because I agree with Walt wholeheartedly that any confusion between those two functions, between the native corporations as landowners and local government in rural Alaska, certainly is not good for the state. I think another thing that I've often found a misconception about with respect to the Land Claims Act is the fact that because the stock that is issued to Alaska Natives under the Act and the various corporations may not be sold for 20 years, there's a general misconception that the land that goes to individuals or to village corporations or to regional corporations also may not be sold for 20 years, and that is not correct. The only limitation on the sale of land, once that title goes to the appropriate native corporation or individual, is a right that is given the regional corporations to review proposed sales by village corporations for a period of 10 years. So while we're clearing up misconceptions, I thought I might state that. John Reeder said in the beginning that he felt, as a lawyer, and he's a very good lawyer and I can vouch for that he has the tools in hand, with perhaps the exception of maybe statewide zoning power outside local governmental areas, to accomplish most purposes. So that raises a question of whether we actually use the legal tools, the governmental tools that we now have in hand to achieve the purposes that become public policy as an expression of our political control. I was going to ask Harry if, in addition to zoning, if there were any prohibitions against using taxation as a means of management control of private lands at the local level. That is, by that I mean preferential assessments for non-use of land as opposed to taxing everybody across the board at the same rate.
Well, there are none in relationship to this act specifically, although Walt, I believe, may have some fuller information. We have endorsed some legislation which has been presented to the legislature, which would give such preferential treatment to those who would hold their land not for self-aggrandizement, but for some laudable purpose, and not merely get the tax benefits and then sell their land at an enhanced value. Something akin to the benefits provided farmers in the lower 48, who are legitimate farmers and not developers, merely holding their land for appreciates the property.
Do any of you want to comment on that, or have you had any experience with that of the use of land other than zoning, but by giving a preferential tax treatment to particular uses of land at a local level?
Well, I think it's done in the lower 48 in very agriculture and farming area. Certainly feasible in the contract.
And there aren't any legal barriers to it that you know of?
Well, there would be if you, depending on the facts you have before you, could have an illegal construction, serious conservation problems, but it's feasible, it can be done. I think for our purposes, you could say that there are no legal barriers to the abstract idea. Invariably, if it was proposed, I think it's better to put it down into language and try to work conservation problems, people protection problems, that's the plan.
Yeah, everybody needs. John has a bad cold. Yeah, yeah. Yeah. John Katz had talked earlier about some of the conflicts between the law and planning, or some of the tensions between the law and planning, and we have all talked about the relationship of the individual to government at all levels. I'd like the panel to address themselves as they see fit, maybe to, from their own point of view, considering, as I listened this morning and gathered from the program what you must have talked about the 2 days before, I kind of sketched down about 4 criteria for management systems, whether they be state, federal, or local, or whether they be cooperative, where that is needed, where you might be managing in a buffer zone, for example, between two ownerships, and have a cooperative management agreement. And these are the criteria that I sketched down. One, the effectiveness, of course, of the management system to achieve its objective. 2, its accountability for its actions. And there was some expression this morning on the panel that somehow, as the law is sometimes used as an end in itself, managers of the public lands particularly often manage for the sake of managing without with respect to the being accountable for their actions to the public as a whole. I also sketched down as a part of that a continuing public input into the management process, because I think management, like comprehensive planning, is not something that ceases, but always continues on a day-to-day basis, and it's ever-changing. And its responsiveness not only to people, but responsiveness to technological change. I think Arlen Tussing this morning posed a very provocative thought that apparently there does exist some type of discovery mechanism whereby oil and gas in place can be discovered without drilling a well. And he posed the question as a matter of policy. If this did exist, and you could, I don't know how it works, because I'm not mechanically minded, but suppose you could fly over the Arctic Wildlife Range and discover that it had 30 billion barrels of oil in place, then what would this do to your land philosophy as to the use of the Arctic Wildlife Range? So with flexibility and responsiveness to technological change, and some kind of mechanism for continuing public input, and accountability for actions to the general public, not just to the clientele of a particular agency, but to the public as a whole, and its effectiveness as a land manager, then do each of you, from your own point of view, see any prospects for the future through something like, as Walt mentioned, the A95 procedures in the state, whereby through a central place all grant and aid programs have to be cleared, or something, John, from the standpoint of something like the National Land Use Policy Act, or something in state government, John Reeder, that allows for state coordinative action. What prospects for the future do you see of bettering the management of the lands of Alaska, particularly in view of what has been called the balkanization of Alaska by drawing these lines on a map? And then I'd like for you in the audience to participate too, because I feel like in a symposium that it's not just the people at the front of the room who have something to offer, but also the people who have been in attendance. You want to start off?
Well, I think a couple of things, and perhaps they're contradictory, perhaps not. I think that the existing federal management systems, which I know much more about than the state system, do not work in Alaska in the present state of affairs, and have no reasonable potential for working in the reasonably near future. And that's something that I think the Land Use Planning Commission, the conclusion the Land Use Planning Commission has come to. So I think that there is a demand really to create some new management system. In the process of doing that, I think that we can take cognizance of the really unique situations in Alaska, and they are unique. There's no great group of people in the lower 48 that relies on units of the national park system for subsistence purposes, for example. There is here. Another thing that occurs to me that would be helpful is that in creating a new management system, which I think is required by the empirical facts, we might tend to divest ourselves of the constituent groups which the old management agencies now have. The old management agencies, in my opinion, tend to look at things with tunnel vision in some respects, and they are responsive to a particular group and not perhaps to the society at large. And by creating a new system in Alaska, or at least in lands which don't fit very well into the old system, I think we can divest and start over again with respect to constituencies. But there's another theme that I have felt for a long time, and I think perhaps is important, and that is that I think that except for the areas that John Reeder talked about, perhaps except for the need for new management systems, we have enough laws to satisfactorily regulate land use, whether it be by zoning or by land classification or by cooperative management, any number of techniques. And I'm personally look with great trepidation at what I see as a trend in legislation. We are not finished with legislation. We keep having more. And that legislation tends now to come from above. I mentioned earlier that I think that the sides have weapons in an arsenal and they can pick from them. But as time goes on, in my opinion at least, the federal government is giving itself more weapons, both against the states and the local governments and against individuals. And they're changing the ground rules, admittedly within the confines of the Constitution, but still changing them. And so I approach the National Land Use Policy Act with a great deal more trepidation than perhaps some other people do. In theory, it's a procedural mechanism whereby the federal government will just ensure that certain processes take place, that states are engaged in land use planning and things of that sort. But I've seen too many laws like this before that begin as procedural matters and end up as substantive matters. And there is a concept, for example, in the Senate National Land Use Policy Bill of an environmentally critical area which would be subject to special constraints and controls. And the definition that is in there fits virtually all of Alaska, and certainly an area significantly in excess of the 83 million acres that the Secretary originally proposed. In so saying that, I don't mean to come down either on the side of development or on the side of conservation, because I don't think it's that issue. I just think that the state and especially local municipalities are more responsive to the people and have the tools to do a great deal of good planning. And it disturbs me a great deal that some people feel that the federal government must take over that role because the states and the local governments don't know their own self-interest. I don't think that's true. But with the exception of much needed changes in the management systems, I would like to see the status quo maintained with respect to the regulation of land uses.
Mr. Clements.
I'd like to address a question to Mr. Katz, if I might. At the outset, Mr. Katz, you seemed reluctant to regard the law as a barrier, as is indicated in the title of today's symposium. Rather, I think you would express the thinking of the law as an arsenal of weapons. By your this week's remarks, you seem to have indicated that analogy which you made is a little bit more appropriate in some respects than I believe you intended at the outset. I'd like to ask you, is the prolific availability of an arsenal of weapons conducive to a reasonable conciliation of problems, or would it be more conducive to a prolonged, bitter conflict?
Perhaps weapons isn't the right word. It becomes weapons when all else fails. I think perhaps a better word is mechanism, because a cooperative agreement, if they come to pass between the state and the United States or between the state and, or between the federal government and the natives with respect to land use would not really be a weapon. It would be a product of a cooperative arrangement. I view the battlefield of the court as an absolutely unsatisfactory procedure for resolving these problems. Judges just are not equipped to handle them. They don't have the resources to analyze land use problems. And it seems to me that when you go to court and you're really in an adversary situation, that you've absolutely failed. And so perhaps arsenal is not the right word at all.
Thank you, John. Anybody want, Walt?
The problem is that in order to move into a new management system, you have to overturn so much of the existing system that you have to start defining a new management system on what land.
I certainly don't think it's something that could be answered now. And I think that, well, I sketched out this criteria. I think many of the managing agencies meet this criteria already or are trying to achieve that. They have some handicaps. Certainly, if the BLM had an organic act, there would be some of those handicaps removed so far as BLM management is concerned. I know that this symposium has talked about management on a functional basis, and that was one of the things that I wanted to ask all of us to think about. If, suppose, you wanted to manage on all of the lands of Alaska, and forget for a moment who owns what, forget that there are 40 million acres of native lands, forget that there are state lands and that there are some public domain lands and that there are some other federal lands, but suppose you want to manage a particular thing, flood control or watershed protection, whatever, on a functional basis throughout the state of Alaska. How would you go about it? I mean, would you take these parts of functions away from existing agencies and create a new agency that didn't do anything except look at watershed control? Would you impose a super agency over the existing management agencies and make it responsible for watershed control? I think those are the kind of questions that we're asking, and those are the kind of solutions that we're seeking. But I couldn't give you an answer today, Art. But I think you could. Yeah, and then Doug has a question back there.
Taking it one step at a time, if I had anything to do over again, it would be the Land Use Planning Commission. When I would remove, no. The commission, as Esther well knows, I worked hard to see that commission was established, but the special role of the Secretary of Interior and of the Governor of Alaska, I would have abolished both those roles. We were going to have co-chairmen. One would have been appointed by the President for a term, and the other would have been appointed by the Governor for a term. So we would have had a commission which was able to function independently and to which all federal and state agencies had to come to as equals. That's one institutional change I would have made.
Yeah, Doug, you had a question. And then,
Well, in relation to that question, which I think is really one of the issues I first would think of, the BLM, they ran the whole state. They have the entire capability to do all of it.
Thank you, Doug. Walt, I think, had something that you want. Oh, I'm sorry. Yes.
My name is Vic Allman. Recently, I've had a rumor come to me that I'd like to pin down if I can. I don't know whether to address the question to Walt Parker or Dr. Donahue, but the statement that the way I understood it was that the Anchorage Borough felt that they did not have zoning powers over lands elected by natives within the borough. And I would like to ask if this is true, at what point of time or land title transfer can borough zoning become effective on native selected land?
Our understanding is, subject to some refutation here, is that we have precisely the same authority and power in zoning over those lands, no more, no less than any other lands in the borough.
John?
I think it'd be helpful to try and distinguish in terms that we can't keep using and keep referring to that the government, the state, or the borough has really two functions. One is the state as landowner, and it has sort of a proprietary interest in its own land, and it can do a great many things with its own land. The other function it has is the state is sovereign, and that is the regulatory function over privately owned land. The federal government exercises that with air and water pollution controls, with the Rivers and Harbors Act. The borough does it with respect to private land, with respect to the zoning mechanism. And native lands will be privately owned lands like DuPont or General Motors, and the borough, like the city of Wilmington, will have, within the political constraints, will have the same authority that it does with respect to any other private person's land. There is one constraint, and that is that for a period of 20 years, the lands which the natives receive will be tax exempt so long as those lands are not developed or leased to third parties. If they are developed or leased to third parties, then they're taxable just like anybody else's land. The other thing that's important to mention, I think, is that the Settlement Act requires the establishment of municipal government in villages, or at least 1,280 acres are deeded to the state in trust for a municipal government if it does not exist. That government will be able to accrue many of or all the powers that Title 29 of the state statutes give, and it will have those powers with respect to native lands as well as to any other privately owned lands. One difference may be that many of the boards of directors, the people who sit on the boards of directors in a native corporation, may also, because they tend to be the leaders in a particular locale, will sit on the city council or whatever of the municipal corporation.
I assume, however, John, that they will be subject to conflict of interest laws in the sense that these are profit-making corporations, so they would have to be very circumspect in their behavior if they held these identical offices.
True. Ted? I'm sorry, she was first and then Ted Smith. Yes. What's your name?
I have a question concerning public research, and I'd like to direct it to John Katz.
What is your name, please?
My name is Sharon DeGarza.
Thank you.
Can you find out ahead of time if there's public meetings over your village home or if there's going to be?
Yeah, I think the answer is yes, through mechanisms established in the BLM regulations and through mechanisms that the Commission has established on its own. The BLM regulations require consultation with the appropriate native corporations prior to the reservation of easements, and the Secretary of the Interior will do that, or if he delegates that authority, the BLM and the state will do it. But that must be done prior to the reservation of easements. In addition to that, the Commission has directed the staff to go through a process of consultation with native groups long before the staff makes any recommendations to the Commission. And so as soon as the Commission receives a 90-day easement notice from the BLM, the staff, largely through Janet McCabe, who's one of our land planners, begins to contact the village and regional corporations involved and solicits their views and solicits the views of any appropriate government agency and tries to combine them and get a consensus. If she can't get a consensus, then she goes to the Commission with her recommendations together with whatever submissions she has, and then we will make those recommendations, or the Commission will, to the Secretary. But there should be public involvement both by the Secretary and by the Commission all the way around.
What is your technique in identifying these public uses? Does it include only the recreation, or does it also include the hunting, or does it include only the access?
Well, I believe as a matter of law, and I think the Commission has adopted the position that we have, and the Secretary of the Interior only has the authority to identify easements which are used for access or use easements that are directly related to access. For example, a campsite or a recreation site. Perhaps the archetypal example would be if there were a 100-mile trail, the Secretary of the Interior would reserve a campsite of 50 miles or 25 miles to enable people to rest the night and go on. But I don't think that there is the legal authority to identify broad blanket use easements, only access easements. And to get at those, we have solicited views to try and establish a database. We've solicited views from all the government agencies we can think of, all the private user groups that seem to have an interest in a particular place, and all the government entities. But that, database will be supplemented when we get an official request from the Interior Department respecting a particular parcel of land. Then we'll go back and do it all over again, so that we have two shots at that process.
Thank you, John.
What year can an easement be put?
Well, I think that covenants can be written into the easements that sort of circumscribe the use, and I hope that will occur. There are some requirements in the regulations that says that an easement must be used by the year 2001 or it reverts back. That people should use that as their planning time frame in identifying easements. All those, kinds of strictures. Is that completely responsive to?
Well, for example, I have a native allotment, and if there is a need for a road or transportation access over that land, could they put an easement over my land?
No. That gets into some very complicated
Yeah.
legal problems. But our function does not deal with native allotments. It deals with lands that go to
Or
village
lands
meetings.
with valid existing.
Right. And the Secretary has certain discretion vis-a-vis native allotments that are a totally separate matter from what we're talking about now. And there are some questions, and he's indicated that he may, in the use of his discretion, not convey certain lands or include it in the patent if it's required for an easement. But the function that the Commission is going through is not related to that at all, and we would consider a native allotment a valid existing right. And I think that the Secretary would be much more circumscribed than was first indicated in identifying easements on native allotments.
But then in 17B2, it states that, I'll read this, that any valid existing right recognized by this act shall continue to have whatever right of access is not provided for under existing law, and this subsection shall not operate in any way diminish or limit such rights of access.
Right.
How broad is the Secretary's authority?
Well, that refers, if you have a provable right of access to your native allotment and it existed on the date of the reenactment of the Settlement Act, then you will continue to have that as a matter of prior law. There will, that's why I referred in that list of sources of law to, for example, 43 U.S.C. 932 creates public easements or public highways by virtue of public use over a period of time. That will be the source of many valid existing rights at the time that you're talking about. And they won't be affected by the Settlement Act. They'll be the same as your native allotment itself.
Thanks, John. I think we have until 4 o'clock for our room, so we cut a little bit short on our time. I'm sure John will be glad to talk with you later after this session on any particular problems. Ted, you had a question, and I'm going to open it to Ted Smith. Huh? Didn't you have a question?
Well, I was going to answer your question.
Oh, all right, good. I'd rather have answers than questions. Yeah. Uh-huh.
Thank you, Esther. We appointed a rapporteur for this session, covering all 3 days. And in order to avoid having the biases of some of us who have been at this for a long time now creep into the reporting, why we selected a student in the master's program in public administration here at the university. And she has assured me that she has no biases, and I think, we discussed a great deal the function of a rapporteur, which is an old term held over from the diplomatic conferences, which the United Nations still uses quite a bit, and rapporteurs can have many functions. They can make of their job really what they want to, but as I told Susan, the rapporteur is a highly sought-after job by many people because since you have the final say and are supposedly coming up with what the consensus of the conference was, why, that's as good a place to set policy as any. And I don't think Susan is going to come up and set any policy, are you, Susan? Anyway, this young lady's been sitting down here for 3 days madly scribbling away so we can forward a report on this conference to you, and after she finishes her report, I think she has earned a large hand for all of the work she has done and all the writer's cramp she's achieved down there. Susan Callan.
Next to the long, long string of very fine speakers that we've had, I don't have to say I feel terribly inadequate. It's very obvious. The program says wrap up, and I'm very, very thankful to Wanda for putting that in there instead of summary, because I feel quite strongly about the fact, my only bias, that a summary at this point would not only be inadequate, it would be inequitable and not do justice at all to what has gone on in the last 3 days, which you'll hear. So in the next week, I will endeavor to write a summary, which I hope will do justice to all sides and issues presented. Apart from being a public administration student, I think my presence here could better be explained by being an average citizen. I do have some biases, but other than that, I come with more or less the information that filters down through newspapers, friends, some informants, and so on. The normal biases that I was brought up with, that I was educated into, and probably the most important part is my normal, natural concern for preservation of my lifestyle, which I hold dear, and a lifestyle which I think would be good for generations to come. And it's in this context that I really want to make the few observatory statements. A former microbiology professor of mine, when I was an undergraduate, coined a term which he called connexity and defined it as the interrelationship of all things. And I think it's an apt word for summing up what has gone on here in the last 3 days. As an average citizen, how would I know that watershed management underlies and creates a basis for my very existence? The water I drink in the morning and the skiing that I do in the woods in the afternoon all have to do with watershed management. And to me, this is a beautiful example of connexity. While we've had a lot of information exchange here, a lot of learning done by everybody to varying degrees, I think we all can safely admit that nothing new has come across the podium or across the tables. Nothing devastating as far as revelations go. No really new data. Ergo, are we a failure? I think perhaps not. I think we are an outstanding success. Last night at the banquet, the president-elect of National ASPA, Mr. Philip Rutledge, said in his speech that policy is no longer so much set as it is negotiated. And for effective negotiating, you need more understanding, knowledge, candor, and exchange than you do in effective dictating, which is
the old system, so to speak. I think that's also inherent in what has gone on here in the last 3 days. Phil also quoted Elliot Richardson's favorite expression of saying, where you stand depends on where you sit. Very apt. And I would like to add to that that knowing where you stand depends on knowing where other people sit. And I think that that probably is closer to the essence of what you have accomplished in the last 3 days than anything else. But I see a few other things as a neophyte and as an outsider to being a working part of the environmental scene. I saw in, this afternoon we'll have to take exception to this, but I saw in most of the presentations a call for cooperation and help. Each person who represented an agency or each person who represented a cause called for help and cooperation on the part of everyone to create a consensus for a land use management policy. But I saw a reversal of this in the discussion periods when people then started to take defensive stands for their own positions. We're all human and this is normal. The attitude in the discussion more or less went towards what has been said before. You can do anything you like as long as it doesn't affect me, or in this case, my agency. So what I really see then is a good beginning towards a consensus, which I think is a long time in the future, and something that we're all going to go through a lot of frustration and compromising to reach. In wrapping up, I'd like to take the prerogative to offer an answer to the theme's question after the Land Use Planning Commission, what? I think the what will be other commissions. They will come under different guises because they will have new goals determined by new times, new people, new needs. And they'll have new impetus for bringing this consensus closer to every single one of us. That's all I have to say.
There's one final note from me, and I'm not the last one up here, so don't leave after I finish. We are going to try to publish a form of proceedings from this. In fact, I'm pretty sure we'll have enough.
I'm glad to have the chance to kind of call it to a halt. When I thought about doing this, I wondered which of my hats I would put on to do it. Like so many of you, I wear several. So I thought I'd don the one labeled co-director of the Anchorage Higher Education Consortium. We're very fortunate here in Anchorage to have both a public and a private university. And I think probably we're even more fortunate that both of those schools consciously work together to give us the best part of each. And so on behalf of the two universities that make up the consortium, the Alaska Methodist University and the University of Alaska, I want to thank you all for coming, and I hope it will have been worth your while.
Equated with